one else was in the room where it happened, the room where it happened, the room where it happened. No one else was in the...
So, in our first video on Federalist 78 and Margaret versus Madison, we saw that Hamilton, that is in Federalist 78, he thinks that the reason of judges is needed to protect the principles that are embodied in the Constitution. The power of the legislature, he says, is a threat to that reason. So the judges actually need protection from being removed from office if they're going to be able to stand strong against that power. That's why they need to hold their offices as long as they exhibit, quote, good behavior and not be removable for any other reason. In this video, we're going to see more about how he develops that argument, and especially how he thinks that time contributes to the reason of the Constitution. How it is that the earlier, prior decisions of the Constitutional Convention are more likely to embody reason than the later and perhaps power-hungry acts of legislatures. Right? And once we've seen that, we're going to actually move on to Marshall, who focuses less on the reason embodied in these decisions that are made prior in time. He focuses instead more on the power of the court to make decisions, which is precisely what scares opponents of judicial supremacy. That is, it is a doctrine of power, not of principle, they say. At any rate, let's continue on with Hamilton's Federalist 78 first, to get to Marshall later. Hamilton says in the first half of the essay that the court is weak because all it has is its reason. But then in the second half of the essay, he says it's actually quite strong because it has a mission to protect the Constitution, which is, that mission is superior even to the mission of the legislature itself. So on page 2, we see the theme of superiority coded in magenta. We see the theme of that superiority of the Constitution emerge, and Hamilton's question is, who best to protect that superiority? So Hamilton makes an argument about the role of judges in protecting the people from things that are against what he calls the, quote, manifest tenor of the Constitution, or against the Constitution as what he calls, quote, fundamental law, a very important concept for us. That is, the law that forms the foundation for all other law to come into existence and is therefore superior to all other law. So notice then that the superiority of the Constitution necessarily means that there are two levels of law, let's call it, or two types of law. Those are in operation at the same time. Ordinary statute law, i.e., law made in the ordinary course of legislation, that is, it's created by statutes, as they're called. And the second level of law, fundamental law, made at what I previously called a constituent moment in time, a calmer moment of deliberation, as some people will say. So then Hamilton's question becomes, what do you do when these two laws conflict? And his argument regarding this, which you'll see on page 3, is that when any two laws conflict, regardless of whether it's a fundamental or a statute law, when any two laws conflict, the prior would be considered to be superior. It takes precedence, and the later, he says, is subsequent and inferior. So here we have the issues of time, coded in green. Hamilton says it's prior over subsequent law. Right? And we have the issue of superiority, coded in magenta. It's superior over inferior law. So as he says on page 3, and this is coded in yellow because it's about the power of the court, he says, the courts must declare the sense of the law, he's saying, in any of these sorts of instances of conflict between two types of law. Okay, so then, what are his examples of the instances when two laws might conflict? His first example are clear provisions within the Constitution. You'll see him address these on page 2. For instance, he looks at the clause that says no ex post facto laws. That is, no laws that make something a crime after the fact of the commission of the act itself. He also looks at the thing that says no bills of attainder in the Constitution. A bill of attainder would be something that attaints a family member. Because, for instance, I committed a crime, my grandfather and my child would both be considered guilty and punished in some ways. So when the Constitution says that you do no laws of this character, that, Hamilton says, stands before and is prior to any later statute. So if Congress made any such law, it would have to give way, that law would have to give way to this prior constitutional requirement forbidding these laws. His second example then, and he talks about these examples on pages 4 to 5, is the violation of rights. And here we'll see that time and reason play the biggest roles. So notice how he explains rights violations. They're not only later in time than the Constitution, but they're also temporary. Another concept about time. They are, that is, laws that violate rights, they're sort of a fleeting voice that's contrary to an enactment of the Constitution that speaks for all time. So for instance, he says violations occur when a, quote, momentary inclination happens to lay hold of a majority, or when he says occasional ill humors. And he contrasts these things with the solemn and authoritative acts of constitution making. So the legislature then is being said to act from motives that are temporary and transient, momentary inclinations, occasional ill humors. And it's also being said to act from motives that are ill-considered and impetuous, or that is, unreasonable, momentary inclinations, not reasons, occasional ill humors, not reasons. On the other hand, the judiciary is always said to act from timeless and well-considered principles, the principles of the Constitution. So for Hamilton, the prior and superior judgment is a judgment of reason. And the skill of the judge then is in applying reason to block those momentary inclinations of the majority. He says, for instance, on page 4, that the judiciary has integrity and moderation to do these things. He says on page 5, there can be but few men in the society who will have sufficient skill in the laws, or who will, he says, unite the requisite integrity with the requisite knowledge. So look for that coded in blue, a statement about the reason that judges possess. And he says they possess the requisite knowledge to resist what he calls the ordinary depravity or unreasonableness of human nature. Integrity and knowledge, right, are positioned then against inclinations and humors and depravity. So, do these themes show up in Marbury versus Madison? Okay, so first let me actually tell you something about the story of the case, casually, like this, so that we can get back to the formal lecture about the concepts that you're going to find in that case. So Marbury versus Madison was a case that emerged at the beginning of the Jefferson administration. At the end of the Adams administration, in 1801 that would be, Adams signed the commissions for a number of judges to take spots on the federal bench, but in particular, the commission for Marbury was a commission to become a justice of the peace in the District of Columbia, that is the federal district. For these commissions to take effect, he had to send them to his Secretary of State for them to be signed. But here's the thing. His Secretary of State was a guy named John Marshall. And John Marshall had already taken over his role as Chief Justice of the Supreme Court. That is the very John Marshall who writes the opinion in Marbury versus Madison. Okay? So he had already taken his role as Chief Justice of the Supreme Court and basically just dropped the ball on doing the Secretary of State roles. The Jefferson administration takes over, and now James Madison is the Secretary of State. Mr. Marbury hasn't gotten his commission, the slip of paper that actually would give him the power to be a Justice of the Peace in the District of Columbia. So he sues James Madison. He asks for what's called a Writ of Mandemus. You've probably read the term before, but maybe never actually thought about what it means. It's a type of writ that a court can order to mandate, mandemus, to mandate that a government official do the thing that it is their official duty to do. So he's trying to mandate that James Madison actually hand over to Mr. Marbury himself the commission that the former president, Mr. Adams, had signed, and that the now Chief Justice, Mr. Marshall, had actually failed to sign. Now, on to the concepts in display in Marbury versus Madison. Lots of people have noticed that time and reason don't actually play big roles in the justification of judicial review in Marbury, but power and superiority do. And as I've said to you before, their fear was that this meant judicial supremacy. In claiming the supreme law wholly for itself, the court would be seeming to give the judiciary supreme power too. So you can see it visually by looking at the color-coded document. How much of it is coded yellow and magenta for power and superiority? So for instance, take a look at pages 3 to 4. It mentions multiple times that the Constitution is, quote, fundamental law, superior law. And it uses the same argument as Hamilton does about superiority. On page 3, time does show up in green, that's for sure. Marshall says this. He says that the people have an original right, a right at the origin, time, right? That the people have an original right to establish for their future government such principles as, in their opinion, shall most conduce to their happiness. And he mentions that these principles are permanent and, as I've said, original. But the big theme is superiority, coded in magenta. On page 5, for instance, he says that the Supremacy Clause mentions the Constitution first as supreme, not all of the laws of the United States that the legislature should make. And note, we're actually going to see in our next class that the phrasing of the Supremacy Clause of the Constitution is way more ambiguous than Marshall suggests here. It's not at all clear that it's meant to give federal judges the power to sort of enact or enforce this supremacy. But like I said, more on this later when we talk especially about the works of James Madison. Now, Marshall claims that the Supremacy Clause justifies this conclusion about power. It's on page 4, it's coded in yellow. It's perhaps the most famous quote in Supreme Court history. He says, "It is emphatically the province and duty of the judicial department to say what the law is." Like Hamilton, he then asks on page 4, if two laws conflict with each other, the courts must decide on the operation of each. And in answer to this, he gives precisely Hamilton's types of examples. So take a look on pages 4 to 5, where he makes those arguments that Hamilton made about the express provisions of the Constitution. For instance, there are rules in the Constitution that say no taxes or duties on imports from one state to another, that is. Right? If it says no, it means no, Marshall says. No bills of attainder, no ex post facto laws. And Marshall says, look, if courts can't enforce these express provisions, who else could enforce them? If the legislature makes such a law, it is the province and duty of the Supreme Court to strike it down. But we might think that he's actually gone a bit further than Hamilton here. Hamilton surely thought that it was the duty of the court to act in those circumstances, but is it the peculiar province of the court to do that? Can't the executive act as well? Let's say she sees a law that she believes is unconstitutional. Can't she refuse to enforce it? She is sworn to uphold the Constitution too, right? And notice also that in Marbury versus Madison, there's no particular mention of individual rights, only of the enforcement of express constitutional rules. Another way in which this decision differs somewhat from Hamilton's piece that we read. Now, the rest of the story of Marbury versus Madison does actually show that Marshall was concerned with the, quote, natural rights of Mr. Marbury being violated. For those of you who are interested in those arguments, they're in a part of the case earlier than the part that we read. They're simply not in the excerpt that we read. But if you're interested in those, take a look, read them, set up some time in office hours with me, because you may actually be able to write about those arguments in a later assignment. At any rate, having asserted that the Constitution is supreme, and the court is really the only body with the power to enforce it, Marshall then has to show that there's some element of the Constitution that conflicts with the law in question in the Marbury case. The law here gave the court, quote, original jurisdiction to hear cases for writs of mandemus. Congress had actually said in the Judiciary Act of 1789 that the Supreme Court should have original jurisdiction over such cases. That is, the power to hear these cases first, to be the origin of those cases, before any other court could hear those cases. Now, that law seemed sensible to Congress. If the president, for instance, refused to enforce some law in your particular case, you'd go to a federal court to try to force him to act. And he might say, it was unconstitutional, therefore I didn't enforce it, and so on and so forth. The argument could go on, but it seemed to make sense to Congress that if someone wasn't doing their official duty, you'd turn to a federal court to try to force them to do it, to get a writ of mandamus. But it's that element of the law that Marshall objected to. His argument is essentially that the legislature cannot give original jurisdiction over the Marbury case to the Supreme Court if the Constitution gave it only appellate jurisdiction. A writ of mandamus is an original act. What if the Constitution didn't give that power? So he relies on this distinction in the Constitution. In cases involving, quote, ambassadors, the Supreme Court, this says, shall have original jurisdiction. In all other cases, it shall have appellate jurisdiction. That's from Article 3, Section 2, Clause 2. And just take a moment to read it over. Now, from that, Marshall concludes that the words are clear. These are the cases in which the Supreme Court shall have original jurisdiction. Those are the cases in which it shall have appellate jurisdiction. And he says, this is on page 2, affirmative words are often, in their operation, negative of other objects than those affirmed. Or, in other words, when the Constitution affirmed original jurisdiction in, quote, cases affecting ambassadors, other public ministers, and consuls, it was by that affirmative act negating the notion that the court would have original jurisdiction in any other case. So Marshall says, so he claims. However, could he really have thought that these words actually create two mutually exclusive categories of this sort? Say, for instance, you sued an ambassador in a lower court, like they violated a contract that they had entered into with you for the sale of a house, let's say. And it is possible to sue ambassadors for things like that. Does the Constitution mean, as in Marshall's reading of it, does the Constitution mean that the Supreme Court can't hear an appeal of that case because it shall have original jurisdiction in cases involving ambassadors? No, of course it doesn't mean that they can't hear appeals in those types of cases. The Supreme Court does not have only original jurisdiction in those cases. It can also have appellate jurisdiction. And likewise, some people say, the court could have original jurisdiction in some of those other cases mentioned in the Constitution as well, because it can exercise both appellate and original jurisdiction in at least some cases. So it's pretty clear that the legislature couldn't remove original jurisdiction from cases involving ambassadors, etc. The Supreme Court clearly has the right to hear such cases first if it wants, but if the legislature sees fit to give it original jurisdiction over some other sorts of cases not enumerated, it's not clear that those words forbid it. It's not clear, at least. You might come away thinking so. Marshall clearly came away thinking so, but it's not straightforward. Now, I want you to look at all of Marshall's really intricate arguments involving this issue on pages 2 to 3 of the reading, because we're going to examine then in some detail what those arguments are when we talk in person, and I'm going to ask you to take a stand on those words like shall have. Right? But to finish the themes of this video lecture, I want to suggest again that Marshall seems to be less concerned with the reason of judges in his Marbury decision, and he seems to be more concerned with the power that they have to enforce the supreme law. And I also wanted to remind you, as I said at the beginning, please do feel free to raise any evidence that you might think would conflict with or contradict the sort of interpretation I've done for you in this lecture. Because the essence of legal argument is using text both for and against a particular claim. Words can be read in multiple ways. And I want you to learn over the course of this semester to understand those multiple meanings. I look forward to seeing you in our next video lecture, and of course, talking with you about these things in our synchronous discussion. I'll see you then.